Okay, well that deals with the IHT 205. But that's just one of the forms you need to prepare. The next form is the Form PA1, which is the actual application form to the probate registry. And you'll note before I forget to mention this, you don't need to sign this form, it just needs to be completed. You'll find this a lot more straightforward than the previous inheritance tax form. But you need to remember that this relates to a different aspect, i.e. the grant of probate and not the tax. Consequently, the questions relate more to the setup of the estate rather than the assets. And I will try to explain the questions so that you know why they're asking for that information. Again, at the top, you will see that there is a reference to websites that you can refer to. So question 1, this is simply about the fact that there is a difference between an application by a solicitor and one by a private citizen. If you are applying privately, then the probate registry will prepare the oath and send it to you to be sworn. All this question asks is where will you be taking the oath to be sworn when you've received it. The standard fee for swearing an oath is £5 plus £2 for any exhibit, which would be the will, so the total cost is £7. Question 2, question 2.1 to 2.5, this asks for information about the person who's died, and you will be able to get this information from the death certificate. Questions 2.6 to 2.11. In particular, please note question 2.8, which asks whether the deceased was based abroad. You will need to bear this in mind later on when you come to question 4. You'll also see that the form focuses a lot on adopted children. If you are in that position, either someone adopted you or you adopted them, then the form asks for more information. You also note the marginal note to 2.9. The form says that you only need to provide a certificate of adoption if there is no will, but it doesn't say this in the questions. So my advice would be that if you are adopted, even if there is a will, make that point in a covering letter. If the probate registry wants more information, they will ask, but at least you've told them. Questions 2.12 to 2.15. These ask about the deceased's marital status. You will see that if the deceased was divorced or judicially separated, then the registry will require some more information. Question 3, the will and any codicil. A codicil is an amendment to the will which has been properly executed. Just to clarify or highlight a few points here, question 3.4. The issue here is that a will is automatically revoked by a later marriage or civil partnership unless there is a special clause in the will avoiding this consequence. If there was a will revoked by a later marriage, then the risk is that the deceased may have died intestate, which may affect who is entitled to inherit under the will. Question 3.5. If there is a beneficiary under the age of 18, then they cannot inherit property or money until they have reached that age. So some form of trust may be needed to hold that inheritance until then. Question 3.6. If a beneficiary to the will, or the spouse or civil partner, witnesses the signature of a person making the will, then that gift lapses, although the rest of the will remains valid. Question 4 asks about a person who is based abroad. If he or she was based in the UK, then you will probably be able to ignore this question. If this question is valid, then you will need to note question 4.3. They ask for a copy of the foreign will, if there is one. 4.4, the value of those foreign assets. And 4.5, the foreign equivalent of a grant of probate. Question 5 is questions about the person's relatives of the person who's died. I don't think there's anything too complex here. The probate registry are asking about relatives to the deceased. It is particularly relevant where there is no will, but you will see that they require questions 5.2a to 5.2c to be answered in all cases. If there is no will, then that position is called intestacy, which governs the right to inherit. This webinar does not deal with that subject. However, if the deceased did die intestate, then you need to be certain that you are the person or one of the persons entitled to apply for probate, as otherwise your application may be rejected. Question 6, about the applicants, i.e. yourself, and you'll see that there's provision for up to 4 applicants. Question 7, this webinar is for people who don't have to pay IHT, so you only need to tick the boxes related to IHT 205, which are questions 7.2 and 7.3. Question 8 only applies if you are applying as an attorney. Box 9 is a very useful checklist. The application fee at the bottom, the fee is £215 for the application itself and 50p for each official copy of the grants. It depends on you how many copies you want, which depends on how many accounts you have to contact, but I would normally recommend a minimum of 10 people, and you may well need more. So that's the PA1 form. As you see, it doesn't need to be signed, just completed, and I don't think, in all honesty, you should have any problems with that form.